The courtroom can feel like a foreign country, a place where the language is unfamiliar and the customs are strange. Lawyers speak a language full of strange words and phrases, terms that can seem like a secret code to outsiders. It can be confusing for anyone who isn't a legal expert. The jargon can make you feel lost and overwhelmed. This essay will explain some common courtroom terms, breaking down the complex language into something more understandable. Understanding these terms will help you navigate the legal system with more confidence. You'll feel more at ease and less intimidated. You might be surprised how often these terms pop up. They're not just confined to the courtroom. You might hear them on TV shows about lawyers where legal dramas unfold with gripping intensity. You might even read them in news articles about court cases, where journalists report on the latest legal battles. Knowing what these words mean can help you understand the news better. You'll be able to follow along with the stories more easily. Knowing legal terms is especially important if you ever find yourself in court. Whether you're a defendant, a plaintiff, or just a witness, understanding the language can make a big difference. Maybe you'll be called for jury duty. Serving on a jury is a civic duty, and knowing the terms can help you fulfill this role more effectively. Maybe you'll need to handle a legal issue of your own. From signing contracts to dealing with disputes, legal knowledge is invaluable. Whatever the reason, understanding the basics will help you feel more prepared and empowered. You'll be able to approach legal situations with greater confidence. So let's dive in and demystify some of these legal terms. We'll break them down one by one. Don't worry, I'll keep it simple and straightforward. By the end of this, you'll have a better grasp of the language of the law. Before a trial even starts, there's a lot of work to be done. This phase is crucial for setting the stage for what will happen in the courtroom. This is the pre-trial phase, a period filled with preparation and strategy. It's like the warm-up act before the main event, where every detail is scrutinized and every angle is considered. Here are some key terms you need to know to navigate this phase effectively. This is the defendant's first appearance in court, often referred to as the arraignment. During this appearance, they hear the charges against them, which can be a daunting experience. They also enter a plea of guilty or not guilty, setting the course for the trial ahead. This is like an interview, but with a legal twist, known as a deposition. A witness answers questions under oath, providing crucial information that can shape the case. This happens outside the courtroom, often in a lawyer's office or a conference room. Lawyers from both sides are there, each trying to gather as much information as possible. Think of this as legal homework, a critical part of the pre-trial process. Both sides share evidence and information about the case, a process known as discovery. This helps everyone prepare for trial, ensuring that there are no surprises when the trial begins. These pre-trial terms are just the tip of the iceberg, but they are essential for understanding the legal process. They give you a good starting point for understanding what happens before the trial even begins, laying the groundwork for a fair and just legal proceeding. The trial is where the action really heats up. It's the culmination of all the legal proceedings that have taken place up to this point. This is where evidence is presented, arguments are made, and witnesses are called to testify. Each side gets to present their case in the most compelling way possible. And ultimately, a verdict is reached, determining the outcome of the case. The jury or judge will decide based on the evidence and arguments presented. Let's break down some important trial terms to better understand the process. This involves a dispute between two parties, like individuals or businesses. These disputes can range from contract issues to personal injury claims. One party, known as the plaintiff, is suing the other party, known as the defendant. The plaintiff believes they have been wronged and seeks justice. They're usually seeking money or some other form of compensation to make up for the harm they believe they've suffered. This involves an offense against the state or society. These cases are more serious and can include crimes like theft, assault, or even murder. The government, represented by the prosecutor, is prosecuting the defendant. The prosecutor's job is to prove that the defendant committed the crime. If found guilty, the defendant could face jail time, fines, or other penalties, depending on the severity of the crime. This refers to who has to prove their case. It's a crucial concept in both civil and criminal trials. In a criminal case, the prosecution has the burden of proof. They must convince the jury or judge of the defendant's guilt. They must prove the defendant's guilt beyond a reasonable doubt, which is a very high standard to meet. Trials are full of drama and intrigue. The stakes are high, and the outcomes can be life-changing for those involved. Understanding these key terms will help you follow along and make sense of what's happening. Whether you're watching a trial on TV or involved in one yourself, knowing the terminology can make the process less intimidating and more comprehensible. Once the trial is over, the judge or jury decides the defendant's fate. Here are some terms you'll hear during the sentencing phase. This means the defendant is found not guilty. They're free to go. This means the defendant is found guilty. They will face some form of punishment. This is where the judge decides the defendant's punishment. This could include fines, probation, or even jail time. The legal process doesn't always end with the sentencing. The defendant might appeal the verdict. This means asking a higher court to review the case. The legal system is full of twists and turns, even after the trial is over. Section 5. Understanding the players, people in the courtroom. A courtroom is like a stage with many actors. Understanding their roles is key to understanding the legal process. Here are some of the key players. The judge, the referee of the courtroom. They make sure everyone follows the rules and procedures. They also make decisions about the case. The jury, a group of citizens who listen to the evidence and decide the verdict. The prosecutor, the lawyer who represents the government in a criminal case. And the defense attorney, the lawyer who represents the defendant. Knowing who's who in the courtroom will help you follow the legal proceedings with more clarity. It's like having a program at a play. Section 6. Evidence, the building blocks of a case. Evidence is the foundation of any legal case. It's what helps the judge or jury decide the truth. Here are some common types of evidence. Testimony. This is what a witness says in court under oath. Physical evidence. This includes objects that are relevant to the case. Think weapons, clothing, or documents. Circumstantial evidence. This is evidence that suggests something is true, but doesn't prove it directly. Understanding the different types of evidence will help you evaluate the strength of a case. It's like being a detective in your own right. Section 7. Motions. The wheels of justice turn slowly but surely. Motions are formal requests made by lawyers to the judge, seeking specific rulings. They're like legal tools that can significantly influence the direction of a case. Here are a couple of common examples. Motion to dismiss. This asks the judge to dismiss the case altogether, ending it early. Motion to suppress. This asks the judge to exclude certain evidence from the trial proceedings. Motions add another layer of complexity to the already intricate legal process, but they're an essential part of ensuring a fair and just trial. Section 8. Rights of the accused, cornerstones of justice. In the United States, everyone accused of a crime has certain rights. These rights are enshrined in the Constitution. Here are a few important ones. Right to remain silent. You don't have to say anything that might incriminate yourself. Right to an attorney. You have the right to have a lawyer represent you, even if you can't afford one. Right to a speedy trial. You can't be held in jail indefinitely without a trial. These rights are fundamental to our justice system. They help ensure that everyone gets a fair shake in court. Section 9. Different courts, different cases, types of law. Not all courts are created equal. Different courts handle different types of cases. Here are a few examples. Traffic court. This is where you go if you get a speeding ticket or other traffic violation. Family court. This court handles matters like divorce, child custody, and child support. Criminal court. This is where criminal cases are heard, from misdemeanors to felonies. Understanding the different types of courts will help you navigate the legal system more effectively. You'll know where to go if you ever need legal assistance. Section 10. Why bother? The value of legal literacy. Learning about legal terms might seem like a chore, but it's more important than you might think. Understanding the basics can make you a more informed citizen. You'll be able to follow legal news and current events with greater understanding, help you protect your rights. Knowing your rights is the first step to defending them. Give you confidence in legal situations. You'll feel less intimidated if you ever have to deal with the legal system. Legal literacy is power. The more you know about the law, the better equipped you'll be to navigate life's challenges. So keep learning, stay informed, and remember, Knowledge is the best defense.